Ready? Start. This petition has been filed under Article 137 of the Constitution of India, seeking review of the judgment dated 9/10/2014 in Criminal Appeal No. 1795 of 2009 full stop. The petitioners were convicted for offences under sections 302 and 449 read with section 34 of the Indian Penal Code, 1860 and sentenced to death for offence under section 302 read with section 34, IPC and 10 years of rigorous imprisonment for offence under section 449 read with section 34, IPC full stop para. The conviction and death sentence imposed by the trial court was upheld by the High Court of Jharkhand by an order dated 2/7/2009, and the criminal appeal filed by the petitioners against the said order was dismissed by this court by its judgment dated 9/10/2014 full stop in Muhammad Arif versus Registrar, Supreme Court of India, This court held that review petitions arising out of appeals affirming the death sentence are required to be heard orally by a 3-judge bench full stop. Pursuant to the said judgment, this review petition is listed for open court hearing full stop para. At the outset, it is necessary to set out the scope and ambit of the jurisdiction of this court in hearing review petitions full stop. Article 137 of the Constitution empowers the Supreme Court to review any judgment pronounced by it, subject to the provisions of any law made by Parliament or any rules made under Article 147 of the Constitution of India full stop. Order 47 Rule 1 of the Supreme Court Rules 2013 provides that the court may review its own judgment or order, but no application for review will be entertained in a civil proceeding except on the ground mentioned in Order 47 Rule 1 of the Code of Civil Procedure 1908 and in a criminal proceeding except on the ground of an error apparent on the face of the record full stop para. An error which is not self-evident and has to be detected by a process of reasoning can hardly be said to be an error apparent on the face of the record justifying the court to exercise its power of review full stop. An applicant cannot be allowed to re-argue the appeal in an application for review on the grounds that were urged at the time of hearing of the appeal full stop, even if the applicant succeeds in establishing that there may be another view possible on the conviction or sentence of the accused that is not a sufficient ground for review full stop para. This court shall exercise its jurisdiction to review only when a glaring omission or patent mistake has crept in the earlier decision due to judicial fallibility full stop. There has to be an error apparent on the face of the record leading to miscarriage of justice. Justice Mohd in Sudam versus State of Maharashtra held that review petitioners cannot seek reappreciation of the evidence on record while hearing review petitions full stop para, keeping in view the aforementioned principles laid down by this court, we refer to the facts that are necessary for adjudication of the present review petition full stop. The prosecution case is that there was a dispute relating to property between the review petitioners and their brother, Hanif Khan.